All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state in this honorable court. Be seated.
Thank you. Good morning and welcome to the North Carolina Court of Appeals. We have one case for oral argument on the docket today, Birchard versus Blue Cross Blue Shield, North Carolina. We would like to welcome everyone here. I'd like to introduce the panel. My name is John Tyson. To my right is Judge April Wood. To my left is Judge Jefferson Griffin. This will be the argument. We will take a brief recess and then we will reconvene the panel to administer the oath of office to 4 new attorneys after we welcome all of you here this morning too. So if there's nothing further, I'd like to introduce Roderick, our clerk of court, and Richard Remilliard, who is our court marshal, who's with us today. So if nothing else, we will hear from the appellant. Good morning, Mr. Nickel.
Good morning, Your Honor.
Welcome to the court.
May it please the court. I'd like to begin. I have 6 essential points to make, and I'd like to begin by mentioning something that I think I overlooked in the briefs.
Would you like to reserve any time for rebuttal?
Oh, sorry, Your Honor. I'd like to reserve 5 minutes, and I have informed Roderick.
Thank you.
With regard to the issue of exhaustion of administrative remedies, I have cited 3 statutes that provide 3 different levels of administrative remedies and do not include the Industrial Commission. I neglected to mention that the first amended complaint that I filed in paragraph 33 also says that is required by, and I cite 2 of the statutes, the plan provided for a first-level grievance review, a second-level grievance review, and an external review. And then in paragraph 34, the first amended complaint alleges that Dr. Birchard exhausted all of those remedies. So the statute makes clear that those were the only remedies required by the contract, by the plan, by the health insurance plan. And on Rule 12b-1, motion to dismiss for lack of jurisdiction, the defendant could file documents, but the defendant has not filed any documents, so the court must accept the allegation of the complaint that those are the only levels of administrative review required by the contract. I would also like to mention that the Industrial Commission is not an administrative agency, it's a court. I'm aware that the North Carolina Supreme Court has said that it's kind of like an administrative agency in 2 cases in which the court was explaining the limited jurisdiction of the Industrial Commission. In both of those cases, the North Carolina Supreme Court was saying that the Industrial Commission does not have authority to determine constitutionality of a statute. And those cases are In re Redmond in 2017, which relied on Hogan against Cone Mills Court in 1985. So they said that it's a court of limited jurisdiction. In that respect, they did comment that it's kind of like an administrative agency of the state. But of course, when we talk about exhaustion of administrative remedies, we're not talking about exhaustion of administrative remedies of the state, but more or less internal administrative remedies before going to court. And here we have 2 internal, completely internal administrative remedies, and then 1 external administrative remedy that's provided by the contract and by statute.
Would jurisdiction before the Industrial Commission solely be under the State Tort Claims Act?
No, Your Honor. Section D of the statute creating the Industrial Commission does provide that the Industrial Commission has jurisdiction over claims against the state health plan for essentially non-payment, which it calls claims in tort. So it calls those claims in tort, even though our claim is in contract, and that seems to be more correct. But it does essentially, by calling it a tort claim, seems to be aligning it with the provision for claims under the Tort Claims Act.
We recently had a case involving injuries by law enforcement that was brought in the State Tort Claims Act before the Industrial Commission, that the court held that intentional torts are not cognizable. Only negligence claims are cognizable in the State Tort Claims Act.
Yes, Your Honor.
So if intentional torts are not cognizable where they can do negligence, how can contract claims be cognizable?
I agree with that also.
Okay, so you're not alleging there's any recourse before the Industrial Commission?
None whatsoever.
The other question I wanted to ask you relates to the remedies that are available. And what comes to my mind is like an arbitration, where the parties agree that any disputes will be settled through arbitration or some non-judicial means. Can the parties contract to settle disputes through a non-judicial forum?
Can the parties contract to do that? Well, that's what arbitration is about, I think, so I think the answer to that is yes.
So can a contract between two parties limit the parties solely to a non-judicial resolution?
I think that that's what the arbitration cases do hold, yes.
Could that be true here?
No. There is no provision here whatsoever that the parties are limited to the internal grievance processes or the external review process. No agreement to that effect at all. Moreover, the statute expressly provides that that's not the case, that the person in Dr. Birchard's situation is not bound by the decision of the external review if she has other remedies, such as the remedy she's asserting in this case.
So your complaint alleges that she exhausted the two internal reviews plus the external review?
That's correct, Your Honor.
And that's all that she was required to do before
That's
seeking,
correct.
under your theory, judicial relief?
Before she files in court, yes.
Okay.
Which I think is standard. I'm not aware of any situation in which after administrative exhaustion of administrative remedies, a person cannot go to court then.
Well, I go back to the arbitration claim. You cannot relitigate the claims in court if you've resorted to arbitration. You do agree with that?
Yes, if it's arbitration, but the contract, there's nothing in the contract that provides that this is arbitration or that this is final or binding in any respect. And of course, we don't have the contract in the record, so we have to rely on the allegations of the first amended complaint, which are binding on the court. And those allegations don't say anything about the administrative review processes being binding or final or determinative or constituting an arbitration. It actually does say that a person has to exhaust their administrative remedies and then that they have a certain period of time to file in court, to file after that. So certainly there's nothing to suggest that the contract considers this equivalent to arbitration.
Let me ask you something in Judge Grind's order. I'm on record page 94, which is the first page of the order. And I want to ask you about this too. The second sentence of the second paragraph, I'll give you a moment.
Okay. I don't have a paged, I want a copy with page numbers, Your Honor, but you say it's in?
It's the order appealed from.
Okay.
It's Judge Grind's order.
Okay. Okay, I have that.
Second paragraph, second sentence says the court notes that plaintiff concedes that jurisdiction for this case lies in the Industrial Commission rather than the Superior Court with regard to defendant SHP.
Yes, Your Honor.
Can you enlighten us on, aren't we bound by that too?
Your Honor, we first had a hearing on motion to dismiss before another judge. At that hearing, the judge asked me, why didn't you sue the state health plan? So I quickly filed an amended complaint that added some allegations, but also added the state health plan as a defendant. That was a mistake. I did not have a claim against the state health plan. I don't allege anything against the state health plan. And of course, it's clear that a case against the state health plan had to be brought in the Industrial Commission. So when Judge Grimes asked me that, I agreed, yes. The state health plan, I also agreed that we were probably untimely in terms of bringing the state health plan into the case. So for those two reasons, I did not appeal the claim against the dismissal of the claim against the state health plan. In fact, so I think that actually that language in Judge Grimes' order supports our position, because she says that I agree that jurisdiction over the case against the state health plan is in the Industrial Commission. Clearly, I argued that jurisdiction of the case over Blue Cross Blue Shield of North Carolina is not in the Industrial Commission, but is in the Superior Court.
So your distinction is that the state health plan is not what Blue Cross Blue Shield is offering, or is that what your client?
No, the state health plan is an entity, which is a state agency. There is also a state health plan for teachers and retired state employees that is a contract. I'm just saying that the state health plan as an entity, as a state agency, is not a defendant in this case. I'm not saying that the case does not involve the state health plan contract.
What does the state health plan do? I mean, what is it other than that Blue Cross Blue Shield?
Well, it contracts with Blue Cross and Blue Shield of North Carolina to administer the contract.
Is that the only thing they do with?
I don't know.
Okay.
I don't know whether they do anything. I don't know whether they have anything to do with writing it or what. But they do not administer it. They contract with Blue Cross Blue Shield of North Carolina to administer it. Now, I suppose we could have a claim against the state health plan if our complaint was about the terms of the contract itself being the basis for non-payment. But that's not what our claim is, so we have no claim against the state health plan as a state agency.
Mr. Kell, the state health plan is administered by the state treasurer, is that correct?
I believe that's correct, Your Honor.
Did you join the state treasurer as a party defendant?
No, I did not.
Would that office not be a necessary party since he is responsible for administering the plan?
No, Your Honor. There's nothing that the state treasurer or the state health plan did that we're complaining about at all. We're complaining about the administration of the contract by Blue Cross Blue Shield of North Carolina.
Which was a denial of benefits. That's basically.
Pardon me?
What you're complaining about is a denial of benefits.
Denial.
Of coverage.
Denial of coverage, yes. We're not complaining that the plan itself doesn't provide coverage. We believe it does. We're complaining that the defendant, Blue Cross Blue Shield of North Carolina, denied coverage wrongfully. And I think the complaint alleges in several paragraphs that coverage is provided and that Dr. Birchard qualified for coverage for her inpatient mental health care under all of the terms of the contract, generally under the requirement for medical necessity.
So that was the sole basis they denied the coverage was lack of medical necessity, is that correct?
Well, that's all they said, lack of medical necessity. They talked about criteria, the beacon criteria that they use to determine medical necessity, but they never identified any criterion that Dr. Birchard failed to qualify under.
Does the state health plan, do they contract with any other healthcare providers?
Not to my knowledge. Is there anybody else who administers other than Blue Cross?
Yeah.
Not to my knowledge, Your
Okay.
Honor.
The standards under which the medical necessity must be proven, give me a moment, please. There are 4 factors, is that correct, that are established that the reviewing agency must find?
I think that the criteria were adopted by Blue Cross Blue Shield. They're not provided in the statute. They're not provided in the state health plan.
Are you challenging those application of those 4 factors to the finding of whether or not the treatment was medically necessary?
We're saying that the factors, the beacon factors that they relied on, were improper. But even if they were proper, that Dr. Birchard qualified under them, and Blue Cross Blue Shield erroneously found otherwise.
If I'm not mistaken, the external review is before a medical provider that's reviewing, that's actually external to the internal review. After those are over, don't they bring a practitioner in to review the claim? Is that correct?
We have no information about who made the decision, the external review. The external reviewer was never identified to us, so we don't know. I believe that they...
Did you ask for a copy of that report?
I have a copy of the report, yes.
Does that identify the person who did the review?
Well, to tell you the truth, it's been a long time since I looked at it, so I can't really tell you. I don't know the answer to that.
Was there a basis to offer a contrary opinion or to challenge any of the findings in that document?
We did have an opportunity to do that, Your Honor. I did file an appeal letter from both the first external review decision and the second external review decision, and in both I pointed out that we couldn't tell from the decisions what the criteria was that Dr. Birchard didn't meet or what the basis for the decision was. I tried to guess at what they might have relied on, and I tried to discuss what my guess was, and I explained that's what I was doing, but neither the opinion on the second internal review or the opinion on the external review even addressed the points that I made in my appeal.
So you're not saying you don't know the identity of the outside reviewer, that the physician, provider, you don't necessarily know that you don't know it. And were you given an opportunity to challenge that finding?
No opportunity to challenge the external review decision except in this lawsuit. This is our opportunity to challenge the external review decision.
Now, you mentioned there were 2 external reviews?
Yes.
So your client had 2 internal reviews and then 2 external reviews?
One external review.
Okay, so the internal review was just between an administrative plan, is that correct?
That's correct.
Was that in person or by video, or how was that conducted?
I recall that we had a telephone hearing.
Is there a challenge to any due process about notice or opportunity to be heard at that?
No.
How about the external review? Was there any procedural defects or deficiencies in notice or opportunity to be heard?
We're not claiming that there was, and let me just back up. I have a clear memory of sitting with my client and having a telephone hearing on either the second internal review or the external review, but I'd rather not be bound as to which that was, but I remember only one. But we're not complaining that we were not given a review. We are complaining that the decision in the administrative review was a boilerplate response that did not identify anything about Dr. Birchard that would justify denial of her reimbursement.
So when you went into Superior Court, going back to the order,
Yes.
there were actually two separate hearings before two separate judges, correct?
Yes.
Which, that is what prompted you to file an amended complaint.
The comment by the first judge asking why I hadn't sued the state health plan, along with, I think, the defendants presented this case from Superior Court in Cumberland County from several years ago, where the party sued the state health plan and the treasurer and all those. So I just too quickly went ahead and added the state health plan as a defendant. I acknowledge that was a mistake, and so I've left the state health plan out of the case now. But even if I were suing, even if I did have the state health plan as a party, that would not mean that we don't have jurisdiction in Superior Court against defendant Blue Cross Blue Shield of North Carolina.
Okay, are they, your complaint against them is in their capacity, excuse me, as the administrator of the state health plan, not them individually, is that correct?
I'm not sure I would understand the difference of it.
Well, if the state health plan is the party that is liable for coverage and for payment of care, and Blue Cross Blue Shield is merely the administrator of that plan, then the fact that Blue Cross offers coverage outside the state health plan is not material to your case, is it?
The fact that Blue Cross offers coverage outside the state health plan is not material except to the extent that it shows that it is an insurer and is engaged in the business of insurance. But any policy that it has with any other
Individual or other group.
is not relevant to this, no.
So we're focused strictly on the state health plan and Blue Cross's administration of that plan. Is that correct?
We're focused strictly on the actions that Blue Cross Blue Shield took in its capacity administering under contract with the state health plan. Maybe I can allude to their example of an automobile accident. If the state contracts with some company to perform services for the state, which it does all the time, and for example, provide delivery services, and a driver performing such delivery services has an automobile accident, the lawsuit is against the driver and the principal of the driver, not against the state or the state agency that contracted with that company. So in this case, the Industrial Commission was set up because the state essentially had sovereign immunity. And so the Industrial Commission, the State Tort Claims Act, was established to consent to tort suits against the state for negligence under limited circumstances, and the Industrial Commission was set up to provide for those. So I think that explains why the limitation in jurisdiction of the Industrial Commission is to a state agency and not to an agent or employee of the state agency. And the controlling case on this is Myers against Walls, which the defendant does not even discuss, but it is controlling, and it does say that where there is a claim against the state agency for action of an employee or an agent of the state, the plaintiff can sue the state agency in the Industrial Commission and also sue the employee or the agent in Superior Court.
Which case? I think I saw that. You cite that case, do you know?
Meyer against Walls. We discussed it at length.
Yes.
And that is the controlling case. Now, that case arose under the State Tort Claims Act, but of course the Industrial Commission statute talks about this kind of action against the state health plan as a tort. So the same principle that applies in Meyer against Walls would apply here, and that's controlling. It says the general tort rule that a party may sue the principal or an agent or both. In this case, Meyer against Wall says that if the state agency is sued, that suit must go in the industrial commission. If the agent or employee is sued, that must go into Superior Court. And so you can have two cases going parallel, one in the industrial commission, one in the Superior Court, arising out of the same incident.
Well, again, I go back to the definition, the waiver of the State Tort Claims Act is applicable to negligence claims, correct?
That's correct.
So we just held that there's no jurisdiction in the Industrial Commission for intentional torts
Or contract claims.
or contract
Correct.
claims.
Yes, correct. So the jurisdiction for such a claim would be in the Superior Court.
If the contract itself limits the remedies to an internal review, are you arguing that that would still give you a right to challenge in court?
I don't think I need to answer that question, Your Honor, because the contract does not. So if the contract did provide something like an arbitration clause, I think it did say that that's final and binding and nobody can go any further. That probably
Let me
would be
put it a different
enforceable.
way.
Huh?
Let me put it a different way. Ultimately, your claim is against the state of North Carolina.
No, it's not. We are not seeking any remedy against the state. We don't think the state of North Carolina did anything wrong. Our remedy is entirely against Blue Cross Blue Shield of North Carolina, and we expect our recovery to come from Blue Cross Blue Shield of North Carolina
As the contract administrator.
in its capacity at administering that contract, just as if it were the agent that contracted with the state and had a driver who drove negligently and caused an accident. So we do not seek any relief against the state whatsoever, or any state agency.
You're into your rebuttal time, so do you want to reserve the rest of your time?
I'm glad to answer any other questions, so I'm here to answer your questions and help with that.
Yeah, I'm set for now, if you want to save your time.
Thank you.
Okay, thank you very much.
We'll reserve the rest of your time for your rebuttal.
Thank you.
Thank you. Mr. Kelly, good morning.
Good morning.
Welcome to the court.
Thank you, Your Honor. May it please the court, for the whole panel, my name is Chris Kelly. I'm with the law firm of Galvin, White, and Boyd. I represent Blue Cross and Blue Shield of North Carolina. With me is Kelsey Dorton, an attorney with my firm. She was on brief. Appellee submits that the trial court's order should be affirmed in this matter. Two primary arguments. One, the trial court was correct in dismissing this matter for lack of subject matter jurisdiction under 12b1 of the North Carolina Rules of Civil Procedure due to the unique statutory scheme governing the state health plan, its utilization review organization, in this case Blue Cross and Blue Shield of North Carolina, and the fact that this involves a health care decision, a non-certification of benefits. Second, the appellate's amended complaint by its own allegations fatally undermines its claims, requiring its dismissal pursuant to Rule 12b6 of the North Carolina Rules of Civil Procedure.
Let me ask you this. Do you
Yes.
agree the state health care plan provides coverage for Dr. Birchard's claim?
I agree that the state health care plan is set up by the state, its terms and conditions are dictated by the state, it is funded by the state, and it has mental health coverage both for inpatient and outpatient for benefits that are medically necessary. So,
Okay.
yes.
So there is coverage on the plan.
There is coverage if it meets medical necessity, which in this case, it did not.
What is the source of the 4 factors that the administrator used to determine whether or not Dr. Birchard would receive benefits?
So medical necessity is defined by the plan documents and actually it mirrors the statute. So the medical necessity statute sets forth the criteria and the plan follows that criteria. And the review, the external review in this case, would have looked at both the medical records, the terms and conditions of the plan, and the medical necessity criteria in determining whether to uphold the denial or non-certification or to reverse it, essentially.
Now, not medically necessary is defined according to what we saw was NMME NMNC 1-101.02. Is that
I
correct?
think that's correct, Your Honor.
Is that a statute or an administrative rule or an internal rule?
My recollection is it's a statute, Your Honor. I don't have it in front of me, but I believe it's statutory.
Okay, we could not find a citation. That's the reason I'm
Okay.
asking the question. We could not find that it's an administrative rule under the North Carolina Administrative Procedure Act. So I'm asking this not to clarify in response to Mr. Nikel's assertion that these 4 criteria are simply internal to Blue Cross Blue Shield.
It is not, Your Honor. My recollection, I was looking at this and I thought I had printed and tabbed it. Here we go. If you look at, I believe, section 58-50-61 of the statutes.
5860
section 58-50-61, which actually is titled Utilization Review.
Okay.
Within that statute, Part 12 of that statute, it defines medically necessary services or supplies, and it has an A through E for the criteria of medical necessity.
So symptoms consistent with the DSM, just looking at some of the factors requiring 24-hour inpatient psychiatric services, expected to significantly improve the member's psychiatric condition with a reasonable time. Symptoms do not result from a medical condition that would be more appropriately treated in a medical surgical unit.
That's part. So what it provides is, for example, it's provided for that medical necessary supplies are provided for the diagnosis, treatment, or cure of a health condition, illness, or injury, except as provided under 58-3-255, not for experimental or investigational or cosmetic purposes. C says it's necessary for and appropriate to the diagnosis, treatment, cure, or relief of health condition, generally acceptable standards of medical care in the community. And the last one is not solely for the convenience of the insured or the insured's family or provider. So that's the criteria for medical necessity. And I'd love to go through the facts as alleged in the amended complaint, talk about the external review process, how all of that is based on statute. And the external review organization, it's all based on statute.
Were there findings made to comply with each of those statutory factors?
There were, Your Honor. If you look at the allegations of the complaint, the external review found it was not medically necessary, and I believe the complaint alleges that the issue was that although treatment for mental health was appropriate, inpatient was not. It was not needed, and that was stated in the review.
Was she provided benefits for treatment?
Yes, for
Outpatient?
outpatient treatment. The issue here was inpatient appropriate, and the complaint itself establishes that Blue Cross Blue Shield set out its criteria. He's referring to the Beacon criteria, which he attacks throughout the entire amended complaint. So it's very clear what the basis for the decision was, and as set forth in the amended complaint.
Let's go back to jurisdiction, which is threshold, which is the basis for Judge Grind's order.
Yes, sir.
And the various parties that are here. Do we agree, or is there any dispute, that the state, through the state health plan, is the payor or the person who's making the payment?
That is absolutely correct, Your Honor, and I would say...
And that's not challenged?
That's not challenged, and I think appellant conceded that, and I would go to the step that I think the court has latched onto, which is that, you know, the result of any appeal is that the state would pay its funds. But what the plaintiff is attempting to do in this case is carve Blue Cross and Blue Shield out as if it were some independent insurer and not the administrator of the state health plan in this case. He wants a remedy against...
Do you agree that if Blue Cross Blue Shield as administrator was negligent, there would be a claim as an agent of the state?
I think that he could bring a claim. We believe it would still be within the Industrial Commission, though, is where subject matter jurisdiction lies by statute. And the reason why is that as the Utilization Review Organization, it is making a healthcare decision which encompasses non-certification decisions by statute. So the healthcare decision is defined by statute. A non-certification decision is defined by statute as a healthcare decision. And then the statute related to liability of the state healthcare plan for healthcare decisions lies within the Industrial Commission by statute. That's what it says.
Is this solely a contract claim, coverage under a contract?
It could be, Your Honor, but whether it's contract or tort, the statute specifically says that liability, it says in tort of the state health plan, for its health care decisions shall be under Article 31 of Chapter 143 of the General Statute. So the statute seems to describe a health care decision, which a non-certification is defined as being encompassed by, as a tort claim.
Okay, well, that's the confusion
Yeah.
I'm having, is because is the denial of contract benefits a contract decision, or is it negligence in making that decision?
I think the appellant in this case has alleged a breach of contract claim, saying that it should have been covered and they breached the terms and conditions of the state health care plan. That claim is properly against the state health care plan, not Blue Cross Blue Shield. I think the complaint is convoluted, the amended complaint's convoluted as to why Blue Cross Blue Shield made that decision. Ultimately, our alternative argument is that once the appropriate internal review process occurred, the levels of review occurred, an external review organization, which is identified in the complaint, he identifies who that organization was, which is vetted and approved by the state as having no connections to the plan or Blue Cross, that is qualified, that's going to have a specialized expert look at it. All that's by statute, upheld that decision, and then the statute
What
say...
What recourse does his client have beyond that?
Well, at that point, the statute specifically says that both the insurer is bound, so the state health plan is bound, and Blue Cross is bound by that decision, and the insured is bound by that decision.
Does the statute say that?
Yes, the statute says it's bound by that decision to the extent that other remedies may exist at law, which we put forth in our brief. If you say that that means they can go against Blue Cross Blue Shield, it undermines Part A. You can't have Part A. How is the insurer bound if it can be challenged in court and it has to reverse itself? In this case, if the external review upholds the non-certification decision, Blue Cross Blue Shield is bound by it. How can it be sued for unfair trade practices, breach of contract, anything, when an external review has upheld it? So we think the statute is very clear in very plain language. There's nothing else Blue Cross Blue Shield in North Carolina can do, or the state health plan, once the external review has affirmed the non-certification. The state health plan and Blue Cross Blue Shield are bound by it.
How do you respond to Mr. Nikel's argument that the precedents clearly allow a suit to be brought against the state's agent?
I think that this is, and if you look at the Myers case, and he does cite that case and the other cases that kind of began with it, they're dealing with county agencies, they're dealing with kind of the general tort claims issues, whereas this has a very specific and unique setup with the state health plan, where a specific statute is dealing with health care decisions and specifically non-certification, which is just not present in the Myers case, where you're dealing with the Department of Health and Human Resources being liable for the Department of Social Services on a county level, which is just not applicable here. This is a very unique statutory construction, and you have to really dig into the statutes and understand how the legislature wanted them to be set up, so that the state health plan in this situation is not embroiled in unnecessary litigation. It's got an appeal process in place to handle this.
If his client has the right to resort to the courts for a remedy, if you're claiming that they do not have that right, wouldn't the statute specifically have to exclude that right?
Your Honor, I think it does specifically exclude that right. It says that the insurer is bound and that the insured is bound. We would submit respectfully that what that is dealing with is, if you have in a third-party case, a finding by Blue Cross Blue Shield that say cosmetic surgery.
Torts is very specific. You can bring those under the state. I think everybody agrees this is a contract claim, this is a coverage claim under that contract.
Correct.
I don't want to confuse it with tort.
Right. And so I think what the statute says when it says other remedies are available, it doesn't refer other remedies against the insurer. Part A deals with that, and Part B too, when it says that both parties are bound by this decision of the external review. To interpret it otherwise is to undo the word bound. I mean,
So you're arguing that's it?
that is it, Your Honor, would be the wording of the statute, and that there is the potential for an additional review within the Industrial Commission, but that they're bound by the decision, and Blue Cross Blue Shield by statute can't do anything once that external review has upheld its decision.
I have a question based on what you just said. The external review occurred, by the way, who sets up the external review?
So the external review is essentially by the Department of Insurance, and by statute, the Department of Insurance gets applications for external review organizations. They review them, make sure they have certain qualifications. They're renewed every 2 years, and by statute, they're required to have a specialist in the area of treatment who's also a specialist in the terms and conditions of health plans to review to determine, if the denial is appropriate.
So I heard you say that once the external review occurs, that both parties are bound by that decision and that's it.
Right.
But then you followed up and said, but they can have an additional review, but it has to occur in the Industrial Commission. So walk me through what your analysis of that is.
I think that's really with regard to the claim of the state health plan, that if a party continues to believe it's somehow something's wrong here, that would be that the statute clearly says liability for the decisions of the state health plan for healthcare decisions, which involves a non-certification, is pursuant to the Industrial Commission. By that statute, there is the ability against the state health care plan to go to the Industrial Commission because it says it can. Even though that statute, which the state health plan has opted into of Chapter 58, and really only that section of Chapter 58, puts forth the external review. So you have to try to interpret them consistently. And so you could argue that under Part B, that's the other remedy provided here, is that by statute it says the Industrial Commission can review that healthcare decision, that non-certification, and look at it as an additional level of review. And that's just because that's what the statute says. I mean, those two statutes are going to have to be interpreted consistent in some fashion, and that's the best scheme that I can determine in terms of how they're structured.
Would you assert that that's a further waiver of sovereign immunity by allowing a claim against the state under that statute?
I'm not sure that is a waiver, Your Honor, because it's set up by
Well,
statute
if you
that
start with
says...
the premise that the state cannot be sued without its consent.
Right.
Period. So
It is a consent to review, and the damages would be, compensatory damages under tort the Industrial Commission can award, which is what? Payment of the benefits. What would be the damages that could be awarded. And so the statute says they're liable.
this is a contract claim. This is not a tort claim. So
I understand that, but it's a healthcare decision that's a non-certification by statute. It says it. It's defined. That's what this is. And it says healthcare decisions liability for that of the state health plan is governed by the Industrial Commission. And it's a quasi-contractual. I think essentially what you would say, and there are other comparable areas where it's a tort claim that rises out of contract, the duty, but it's against, that's how they've described it by statute. They've just described it as a tort claim for a healthcare decision, which is a non-certification decision, which is what Blue Cross and Blue Shield did in this case, and we would submit, appropriately because it was affirmed by the external review organization.
and the damages would be the loss of benefits suffered otherwise payable under the plan.
At that point, the definition of what's allowed under the Industrial Commission in terms of damages would apply as against the state health plan.
Let me ask you this. If they went before the Tort Claims Industrial Commission, would they be bound by the determination of the not medically necessary? Or would they do that de novo?
I think that Blue Cross Blue Shield is. I think that the insured, you could argue that this is one of the other remedies available to it, which would be to take the state health plan to the Industrial Commission to determine if the Industrial Commission agrees with the external review as a final review.
So would deference be given to that external review?
I think deference would be given. Yes, absolutely. In fact, case law that we cited from the Fourth Circuit says that plans can be administrated in this fashion for this reason. And medical necessity is allowed. In fact, the mental health statute, the appellant cites in this case, specifically allows for utilization review organizations and medical necessity decisions to occur related to mental health.
You may continue. Thank you.
My takeaway was, you're saying that it's not artfully written, but you're trying to interpret it the best that we can.
We're looking at multiple statutes here for what Blue Cross Blue Shield is trying to do. And what we do know is that we don't think it's appropriate to carve out and somehow sue it as if it's an independent insurer separate and apart from the state health plan. It's just administrating as a URO. And then when you look at how all of that is set up statutorily, yeah, it is. I think it's a very confusing statutory situation, but I think we have to interpret the statutes as reasonable and as consistent as possible. And I think that's what Blue Cross Blue Shield, the appellant in this case, is advocating in terms of how that should be viewed.
So would Blue Cross Blue Shield, as administrator, have whatever amenities or limitations that the state has on liability?
I think that the way this is set up, that if it's engaged in a certification decision that's upheld by an external review, we just follow the statutes. I'm not sure that the statutes go so far to say it has immunity. For example, let's say if it has a decision that
Would it be subject to punitive damages, for example?
That's not before us, so I haven't looked at that, Your Honor, to be perfectly honest with you. I think what I'm thinking about is, for example, if it has a non-certification, that's reversed by the external review. And in connection with that, someone is ill longer or their disease progresses longer. I mean, I don't know what the law would be on that. I think there's still an argument that that's a decision that goes before the Industrial Commission, and damages there can be compensatory, which could include pain and suffering as well as the payment, but not punitive.
When he also brought a claim under Chapter 75,
That's
unfair
correct.
and deceptive trade practices, which would give him a treble damage recovery plus attorney's fees, correct?
Under that statute, correct, yes.
But generally, that doesn't apply to contract claims.
That's right, Your Honor. And in this case, we think factually his complaint defeats that because his complaint establishes that Blue Cross Blue Shield followed the internal review process with a first review, a second review. Then through the Department of Insurance, an external review occurred that upheld the decision. And it just doesn't support the idea that this is unfair and deceptive trade practices under those facts. You can't. And at best, he has alleged a breach of contract case related to entitlement to benefits. Without aggravating circumstances, you just can't, our 12B6 motion must stand with regard to that claim in that it must be dismissed. And that's, I think, also true for the Healthcare Parity Act claim because the state health plan only opts into Part 4 and external review of Chapter 58. It is excluded from the rest of Chapter 58 by definition, as it is not defined as an insurance company or insurer, such that 58.3-220 applies to the state health plan. So I don't think that applies either, although that statute in Part G allows for UROs and allows for medical necessity reviews as well. I just don't think there's a cause of action. So really the only claim that has a glimmer could be his contract claim, but we think in that situation he's not alleged that Blue Cross failed to follow any policy procedure that was set forth as the URO under the state health plan. It had a first review, a second review, an external review. All of that was upheld by the external review, and there's simply no breach here of any duty owed by Blue Cross and Blue Shield to the plaintiff, if any. And so we think the 12B6 motion carries the day if for some reason it's appropriate to have this case in the Superior Court.
Do you agree that under a Rule 12 standard of review, that we have to take the allegations in the complaint as true?
Absolutely, Your Honor.
And we have to review them in the light most favorable to the non-moving party?
Absolutely, Your Honor. That is the case. It's a de novo review by this court. But I think that this court has to conduct that review under 12B6 or under Rule 12 with the statutes in mind, the statutory scheme in mind, as well as reasonable interpretations. Although it's in the light most favorable to the plaintiff, it can't be unreasonable in this case. The plaintiff
Would you not have to assert the statute as a bar to the claim?
in terms of which statute?
His claims that we've all agreed there's coverage under the plan. So you cannot get a dismissal based on lack of coverage. So if there is coverage and he's complaining about denial of that coverage, and he's alleged that he's entitled, there is coverage, he's applied for coverage, he's been denied coverage, and that's taken as true, would you not have to plead the statute as a bar?
So I guess a couple of issues there, Your Honor. I don't believe that the appellee has conceded that there's a coverage for her treatment, inpatient treatment.
Wait a minute, let's be very careful here. There is mental health inpatient coverage available under the plan.
Benefits are available for mental health treatment, both inpatient and outpatient.
So it's not a facial challenge, it is an as-applied challenge to her.
It is a coverage decision, though, that occurred. In other words, the Blue Cross Blue Shield, as the URO of the state health plan, determined that the inpatient treatment was not necessary, not medically necessary, and therefore there was no coverage. So I want to be very clear on that.
What deference is given to that decision?
Right.
The 12B6 motion.
And we, well, I think that the deference is at that point is by statute, because he pled that the
And
external
wouldn't you have to
review.
plead the statute as a bar?
And I think we did, Your Honor. We pled we pled, get the statute site correct, 58-50-84 as that this decision was binding on us once the external review upheld it. We also pled 12B1 and 12B6, that he failed to state claims. And then in our motion to dismiss, laid out in detail the issues related to why he had no subject matter jurisdiction and why he failed to state a claim.
Okay, in the absence of an answer under 12C, under a Rule 56, in the absence of a filing, when you are at the 12B motion, with the standard review taken as true, light most favorable to him, how can we sustain the trial court's ruling under that standard review in the absence of the statute being pleaded as a bar?
Which statute?
Whatever statute you says that limits his review to the administrative agency or the administrative review or before the industrial commission.
So our motion to dismiss did lay all that out in detail. And so looking at, in reviewing pleadings, the court reviews them in the context of both the case and statutory law.
Right.
And so all of our arguments are based on statutory scheme, and that's why we say there's no subject matter jurisdiction based on the statutory scheme and 12B6, because the complaints are not interpreted outside the scope of the law. You don't just throw the law out or ignore the statutes. You have to look at the complaint in the context of its pleadings and its allegations in the context of the statutes.
So you're saying that taking everything he says is true, giving them the benefit of all inferences thereon, there is no jurisdiction before the Superior Court that any jurisdiction would solely be for the Industrial Commission under the statute.
Industrial Commission against the state health plan, that's correct, Your Honor. And that's because 12B1 is subject matter jurisdiction. So you're looking legally as a matter of law what this is. If a plaintiff pleads something, he can't undo subject matter jurisdiction.
Let's say we accept that as true. How can you still, why does his claim not survive as against the administrator of the state health plan under Myers? I
Because,
understand your explanation before.
Right.
But if a claim is allowed against an agent of the state in court,
right.
then why, in the absence of pleading, why would his claim not survive the motion to dismiss?
Because all of the statutory information says that what he has pled is a non-certification of benefits under the state health plan, which is a health care decision, which by statute says must be brought before the Industrial Commission. against the state health plan. And as a result, he does not have subject matter jurisdiction here as a matter of law because of his allegations. His allegations are that she's a state employee, that she's covered by the state health plan,
There's coverage under the plan.
yeah, that there's certain benefits provided, that that coverage was denied due to medical necessity. She even lays out all the various factors that were considered by Blue Cross Blue Shield in her complaint, that she went through the appeals process, a level 1 review, a level 2 review. She then took it to an external review, which that statute we also pled in our motion to dismiss that said is binding upon Blue Cross Blue Shield. That external reviewer upheld the decision. All of that establishes this is a non-certification decision. All of that establishes Blue Cross Blue Shield is acting as the URO and a managed care entity for the state, and by statute, that must be before the Industrial Commission for a healthcare decision.
You have about 2 minutes. If something else you want to bring before us.
Your Honor, I think you've worn out all my arguments. I appreciate the court's time and your willingness and listening to this very interesting case. Thank you.
Hold on a minute, Ms. Kelly. Are there questions?
I don't have any further questions.
I'm set.
We appreciate your argument. Thank you.
Your Honor.
Mr. Gal?
Thank you, Your Honor. Just like to make a couple of points. One is, if the state had not waived sovereign immunity in this case, the state health plan could not be sued, but Blue Cross Blue Shield of North Carolina could still be sued in Superior Court. So if there were no industrial commission created, we could still sue them. There's no case that says that if the state contracts with any entity, that entity thereby acquires sovereign immunity. I'd also like to say that the state is exempted from the Superior Court by the Industrial Commission statute. It's also exempted from the statute with regard to parity in mental and physical health provisions. It's also exempted from Chapter 75, but that applies, all of those apply only to the state health plan itself as an entity, do not apply to anybody who contracts with the state health plan. And then I'd also like to say, if you were to accept the argument of Blue Cross Blue Shield, how would a person in Dr. Birchard's position or counsel representing her figure out that she had to file her claim in the Industrial Commission and not in the Superior Court? Mr. Kelly, I think, argued about how deep you have to go into all the statutes to figure all this out, and talked about all variety of statutes. But how would anybody know that that's what they have to do, that they have to file in the Industrial Commission? And if we did file in the Industrial Commission, wouldn't the Industrial Commission just throw the case out? The Industrial Commission wouldn't think it had jurisdiction. It knows it has jurisdiction against state agencies only. I'm sorry.
Let me ask you this. I want to try to narrow some issues here.
Sure.
Okay? Does your complaint, taken as true, in light most favorable to your client, does it allege negligence?
Does it allege negligence?
Yes.
It alleges a breach of contract, and it alleges an intentional tort, or 2 intentional torts. But it doesn't exactly allege negligence, no.
Which intentional torts does it allege?
A violation of the parity statute and unfair trade practices.
But you do agree there must be some bad act to justify the unfair and deceptive claim?
Yes.
You agree with that?
Yes.
So if it's a contract claim, the contract claim would not be cognizable under the unfair and deceptive?
Contract claim alone would not be, yes.
Okay.
But we do allege, this is an insurance company. This isn't a corporation engaged in the business of insurance. And the insurance statutes specifically provide that the insurance company cannot engage in misleading statements.
All right, let
cannot
me
engage
clarify
in
that with you.
discrimination.
Let me clarify that with you. Is Blue Cross Blue Shield's actions under this policy, are they the actions of an insurance company or merely an agent administrator for the state?
The statute doesn't say an insurance company. The statute says an entity engaged in the business of insurance. So I think that's much broader, and we don't have to determine whether it is really an insurance company or it isn't. Although several places in their briefs, as I mentioned and point out in a footnote in my brief, my reply brief, defendant does identify itself as an insurer.
Right, but I want to ask this, you specifically said you're making no claim under any private benefit or under anything other than the state health plan, right?
Oh, no, we're making no claim under the state health plan itself. We're making our claim against Blue Cross Blue Shield. Well,
But not as an insurer, as an administrator.
as an administrator of the state health plan, yeah, as an administrator of the state health plan, is that an insurer or not? It certainly is a corporation engaged in the business of insurance. So it is an insurer. I mean, that's the business it engages in, is insurance, and in administering the state health plan, it's arguable it is acting as an insurer, that an administrator of the plan is an insurer.
I'll give you a moment to sum up.
Well, I think that's our case, Your Honors. I think that we have shown that jurisdiction is in the Superior Court in this case, and that we've alleged sufficiently the three claims that we have brought before this court. And we thank you very much for the time and attention and the very careful questioning, I must say.
Hold 1 minute.
I'm good, thank you very much.
Okay, thank you very much. Thank you, gentlemen, for your arguments. Kelsey, welcome to court. At this time, we will adjourn this session, and we will reconvene in a ceremonial session thereafter.
All rise. This session of the North Carolina Court of Appeals is now adjourned. You taking it part two?
No, already have. Okay. Have those.
Okay.
Thank you.
Yes, sir.